Mr. Weldon.
Yes, sir.
We're going to let you present your bill first because the other may be a little lengthy. You're certainly free to do it from your position if you like, sitting there. You got number 12, is that it? Yeah.
Yes, sir. Thank you, Mr. Chairman. This is, let me get to it. House Bill 277. This is LC 211053. And I want to introduce Judge Jolliffe, who's here today. If you wouldn't mind coming up, Judge, and if you don't mind, we're not putting you on a witness stand, but yeah, we are. And he's a juvenile court judge from Gainesville in Hall County.
Glad to have you.
Thank you.
Come join us.
And what this bill does is this just merely deletes on the second page, line 30 through 32, a rehearing that a juvenile would be entitled to in the event an associate juvenile court judge makes a decision in their case, and that's excluding detention hearings or probable cause hearings. And I was hoping that Judge Jolliffe may be able to add some insight into why we need this, and if you could just speak to that, Judge Jolliffe, and to the bill, and whether you support the bill.
Well, our judges asked that this be brought to your attention.
Pull that mic up a little bit closer.
Some of you have been around long enough to know that there was a time when most juvenile court judges were part-time, appointed by the Superior Court judges, and then some were associate judges. The code used to, and in fact, that judge used to be referred to as a referee back in the 70s, I think the last time the code was really reorganized. And so that judge was appointed not by the Superior Court judge who appoints the regular juvenile court judge, but that associate judge or then referee was appointed by the juvenile court judge, so the power of appointment was different. The qualifications weren't the same as the juvenile court judge. In some circuits, the judge's law clerk, even the Superior Court judge's law clerk, would be the associate judge. And so the code used to contain some provisions that required an associate judge's decision to, well, you could get a de novo hearing at some point. That was taken out. The juvenile court judge had to sign off on the associate judge's decision. That was eliminated some time back. So the last vestige of that was this provision that allows a litigant to ask for a rehearing of a case that an associate judge has heard in juvenile court, except for probable cause hearings. So just say a trial, either in a delinquency or a deprivation case, an abuse and neglect case. The litigant could simply request and is granted automatically a rehearing by the juvenile court judge. Well, a couple years ago, the code was amended to change the requirements for an associate judge to mirror what we have as juvenile court judges. 5 years as a lawyer, 3 years a resident of this state, and at least 30 years old. So the minimum qualifications are the same. The only difference in the two now is the power of appointment. Superior Court judges appointing the juvenile court judge for a term of 4 years at a time, and the associate judge serving at the pleasure of a juvenile court judge. In some of our metro areas, Fulton County being a good example, DeKalb, out of our 150 juvenile court judges around the state, about 30 are associate judges, and about half of those are full-time, half are part-time. So in Fulton County, where there is such busy court, if the full judge has to rehear a case that the associate judge heard, maybe it took a day, maybe it took 2 days, it just feels like an inefficient use of judicial time in this era of very austere budgets and counties not being able to hire on help for a juvenile court judge in the way of an associate judge. So this simply would give a litigant the same opportunity to appeal a decision of the trial court to the Court of Appeals or Supreme Court, as the case may be, instead of it having to first be reviewed by the juvenile court judge.
All right. Thank you, Judge. Any questions from any of the members of the committee? I see none. So appreciate your comment. Must cover it quite well.
Thank you.
Judge, if I could ask a question.
Yes, sir.
Mr. Chairman. This doesn't cut off any appeal. This just doesn't give 2 bites at the apple.
Absolutely. The right of appeal remains. It just would go to the appropriate appellate court. And again, because the qualifications are the same, and because one hopes that the Superior Court judges have appointed a juvenile court judge that they trust and feel like is qualified, who will then, in the few counties where the associate judges are still operating, appoint someone who's well qualified. It just feels like a distinction that doesn't need to happen anymore.
All right, thank you very much, Judge. Anything further, Representative Weldon?
Mr. Chairman, if there are any questions, I'll be glad to address any issue that I can. I just ask for favorable consideration by the committee.
Anyone on the committee have anything further to ask of Mr. Weldon? Anyone else in the audience who would also wish to speak on the bill? If not, we'll close off further public comment. The bill is now in the breast of the committee. Chair is open to a motion. We have a motion due pass. Is it seconded?
Second.
We have a second. Do we have any discussion on the motion? Do we have any amendments? There being none, Chair will call for the main question, which is due pass on House Bill 272 as presented. All in favor signify by saying aye. Aye. Opposed, like sign. Bill passes. Favorable recommendation. Next we're going to do is House Bill 415. And this is by our dear friend Representative Atwood.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, before I get started, I have with me today Ms. Patty Baker. She's Clerk of Courts, Cherokee County Superior State Juvenile and Magistrates Courts. Also, Mr. Mike Caro, Special Assistant to the Director of the Administrative Office of the Courts. Unfortunately, Mr. Chairman, Judge Stoddard could not be with us today. He had a jury trial. As a brief overview to this bill that I have before you, the Jury Reform Act of 2011, it will authorize essentially a compelling and inclusive statewide juror source list for use in selecting our jurors at the county level. The Judicial Council of Georgia, the State Bar of Georgia, ladies and gentlemen of the committee, and the Council of Superior Court Clerks, as well as others, have endorsed this effort. This legislation is a result of some 7 years of work by the Supreme Court Jury Composition Committee, chaired by Justice Hugh Thompson, and includes jurors, judges, court clerks, prosecutors, and defense attorneys, and it's been quite a labor. And simply put, with an increasingly diverse population in our state, the balanced jury box is outdated. It's an outdated method that I don't think any longer serves us well. A report compiled by the Applied Research Services, Inc., concluded that the process they have outlined could modernize our procedures to weed out inaccurate information on potentially eligible jurors and will make the process more efficient. Right now, we are missing a lot of folks that should be available for juror service. It will ensure that jury service is more uniform among eligible citizens and more readily fulfill the promise of a jury of one's peers. The problem today is that Georgia alone attempts to meet constitutional requirements for inclusiveness on the jury list by a process they called force balancing. Force balancing attempts to mimic the makeup of an eligible jury population in a county by removing people from the jury list until the percentages of males versus females, black and white citizens, comes close to matching the percentages in the last decennial census. And this process is archaic. It's hard to manage, and the expert report commissioned by the Supreme Court Jury Composition Committee confirms that there is a better way to ensure that all citizens are better represented within the jury pool. And as you can see, the bill amends several titles of the code. There are some 70 sections or so to this bill. In order for the reform proposal and the new inclusiveness source list to operate, the law must be changed to do several things. We're asking to remove requirements related to the old system of force balancing of the jury pool to ensure fair representation of cognizable groups, authorize the Council for Superior Court Clerks to create and distribute the new source list and to collect subscriptions to offset the cost of processing and distribution. We're asking to set for the requirement that the new county master jury list will be used to choose jurors in a random fashion that does not deliberately or systematically exclude identifiable and distinct groups from the list of persons summoned to serve as jurors. I think this part is very, very important, and authorize the Secretary of State and the Department of Driver Services to provide their records to serve as the underlying source list for the final statewide master jury list, and lastly, to provide for the confidentiality of the information in these agency records of jurors. And in turn, the Supreme Court will consider implementation rules that govern the processing of the source list by the Council of Superior Court Clerks, as well as a new standard setting a minimum threshold for inclusiveness of all potential eligible jurors within a given county. The judiciary may from time to time review the processing of the new master jury list to ensure that reasonable efforts are being made to maximize inclusiveness and efficiency. So to sum up, this bill will allow us to implement a better system for jury administration in Georgia. It ends forced balancing. It allows for the use of a more inclusive type of jury list. The process is expected to produce more accurate information for use in determining who are eligible jurors residing in a county, and more accurate address information. The process should help ensure that all Georgians are asked to perform their fair share of jury service. Those who serve often will serve less. Those who don't serve may now be called, because the list will include more eligible county residents. And that's essentially what it does, Mr. Chairman, and I will stand ready for questions.
Thank you. Any questions of Representative Abbott? Let me add to your comments a little bit. We've had the bill in the process of being prepared really since the beginning of the session. It came to us from the commission set up by the Supreme Court as a proposal. It has come not only to the House side but also to the Senate side. So there's a bill being considered on the Senate side, and Mr. Carl, you might be able to, or Holloman, either one, give me some information about where the status is of that at the moment. Do you know?
A full Judiciary Committee meeting tomorrow at noon.
Okay. So what we're both doing is considering basically the same bill. My interest is to be sure we have one of the bills continue on. And my need there is to have certainly our bill hopefully reviewed and approved by the committee. There's one major flaw, I call it, or lacking of completion in the bill, and that is the financial end of it, the appropriation of it. We are, if you look at the last page, you'll see in Section 71, it says the act shall become effective only if funds are specifically appropriated for purpose of this act in Appropriations Act, making specific reference to the act. We contemplate it's going to take somewhere upwards to about $100,000, I'm told, to start the implementation of the act. And that is funds necessary to start doing the work with software and personnel to do the list compilations that will be done for all the various 159 counties that begin bringing in the information. And you'll notice throughout the bill we talk about effective dates for certain portions of the bill. You'll see as an example on page 16 at lines 522, this code section shall stand repealed or reserved 12 months after the effective date of this act. Well, we don't really have an effective date on the act. So I say we've got something that still needs to be addressed. My point in bringing this up is it will have to be addressed and will be addressed before we have sine die, or the bill doesn't get put through. Those are the conditions I'm working under myself. I'm not going to have the bill pass through without the appropriation. I'm not going to have it pass through all the way to go on the governor's desk without knowing that there is going to be an effective date of it. So we're still have that as a limitation to be worked out, and I'm not one that likes to let bills go through and be completed by my committee or even to the floor without having something resolved that is so major. But we're in a situation as important as this legislation is. Those are things that have to be cleared up before we can say it's ready for signature by the governor.
Mr. Chairman, if I could speak to that.
Yes, sir.
One thing this bill does, and it's a key component, a key benefit, is it cuts down members of the committee on inaccuracy. Right now, we have got some of our counties that are sending out summonses, and in one case had something around 50% came back as not being able to be deliverable. I know Ms. Baker can speak in Cherokee County to some of the savings that they would see with this. So overall, I think the money would be well spent.
Thank you. And I think the other part of it is that there's a savings. Certainly, we see it to be hopefully a material savings that each county will receive once this becomes implemented, because rather than having all the work done at a local level, the major part of the work is being done at the central locations, state level, with the list and data distributed among all the 159 counties for their usage.
Well, they'll also be able to use the national change of address list, which will keep people off the list that have moved and that sort of thing,
Right.
which is a benefit for us.
So those are the things we want to bring to the committee's attention. Does anyone have a question they'd like to put to Mr. Atwood at this time? Have no questions. Well, I thank you. You do have one, Mr. Weldon. Why don't you pull your mic down for us?
Mr. Atwood, the affidavits that you refer to, and I'm specifically looking at line 97 through 99, where it begins, "It shall be the duty," with that modification is made right there. So that if someone wants to be excused from service, instead of the way they do it in my circuit, they come up, after they've done establish a veneer panel, they ask if there's anybody who needs to be excused, and then they come up and they tell the judge what the issue is, and the judge either excuses them and they go pick up their pay and they go home, or to go to wherever they're going. Now what they're going to have to do is provide a written affidavit to the court, right?
Yes, sir.
That probably is a better situation for those folks, that way they don't have to walk up in front of 300 people out there and explain that situation.
Yeah, I think it would save on embarrassment a little
Sure,
bit for some of these folks.
sure. Thank you for bringing this bill.
Yes, sir.
All right, thank you. I believe
Thank you, Mr.
if you
Chairman.
would do me a favor, Mr. Atwood, if you would slide that list back across here, I can then look at the names we have on here for others who wish to speak on it. We first have, and I neglected to recognize, we do have Judge Billy Ray with us today. Sorry, Judge Ray from Gwinnett County, and he has also signed up to speak on the bill. If you would please come forward.
Thank you, Mr. Chairman. Again, I'm Billy Ray. I'm Superior Court Judge in the Gwinnett Judicial Circuit, which is Gwinnett County, and just generally want to talk about what a good idea this bill is. Even more so in the most complicated case that we'll ever hear, and that is a death penalty case. It's not impossible that you can have challenges to juries in any kind of case, but in a death penalty case, it takes on even more significance. Because we're not just talking about a sentence of a few years or a few months on probation. I mean, you're talking about the ultimate sentence that Georgia prescribes, and that requires and demands and receives additional scrutiny by the state court, appellate courts, the Supreme Court of Georgia, and also by the federal courts. The force balancing is just a very difficult thing. My county is a pretty good example of that. We've had incredible changes in our demographics in the last 20 years, even more radical probably as far as the degree of change in the last 10 years. It's just a different place, and the census really doesn't reflect that. And I think all judges desire to try a case one time and not to try it again if we can avoid that. I have a good example because I currently have a capital case where the state has filed a notice to seek death, and right now I'm not moving on it. I've had all my pretrial motions except for the challenge to the jury pool that will be under the force balancing, and part of that is because there's been such a change in our county that I'm waiting for the decennial census numbers to come forward so that I can do it under that analysis. With this statute, if passed and funded, I won't have to worry about that in a general sense, because if it's done correctly, there's going to be such a diverse pool of people to pull jurors from that statistically speaking, I'm going to get, in most cases, a jury that's going to reflect our community, and I'm not going to have to worry about it. Now, that doesn't mean a lawyer can't raise a challenge, but we'll be able to tell pretty quickly whether or not the jury is reflective or not. So it's just a better way of doing things. Sometimes change is kind of painful because we all have to learn how to learn some new rules, and the evidence code is an example of that. But the end result is very positive, and so I want to commend the whole idea. I know this has been a 7-year effort.
Yes.
It is sponsored or supported by the Judicial Council. I'm not here to speak for them, but I know that they are supporting the bill, and I am here to speak for the Council of Superior Court judges who do support the bill and would very much like to see it passed. Other than that, the only other thing that I'd want to talk about is just some issues that came up yesterday in the subcommittee meeting. I'm sure the clerk's representative will speak in a minute. There were a couple of things that they were asking for that we objected to. One was the current law allows in a couple of situations the jury clerk, the person who's in charge of all of this on a local level, to be appointed by the chief judge of the Superior Court, or sometimes maybe the vote of the Superior Court judges. And it was requested yesterday by the clerk's authority that be changed to give the clerks of the Superior Court the right to make that appointment. And we don't support that. We would like to maintain, in the instances where the Superior Court has that authority, to continue to have that authority. I will tell you that in many cases, when under current law, for example, if you're a county over 600,000, the chief judge appoints a jury clerk. But in many cases, the chief they have designated to the.
I think they reflected on that situation, Judge, and they've agreed to not be a matter of pushing it.
All right. And then the other issue is that the trial judges in the courtroom where the rubber hits the road want to maintain the control over jury excuses, because we've got to live with a reversal that may occur. So
and then under the current language, you can still delegate. If you wish to have that delegated to the clerk or someone else, you have the ability to do that.
And we do that in Gwinnett County, but in some places they don't, and we want to keep it the way it is.
Okay.
All right, thank you.
Well, glad to have you here, and let me get you to explain maybe some of us on the panel who don't do criminal work about what you call the forced what term you use?
Forced balance.
Forced balance, excuse me, yeah.
Well, what that does is our county is a good example. We're approaching 1 million people, but we don't have a jury pool of 1 million people. We have a jury pool of about 400,000, because it's been a lot easier, for whatever reason, to capture in our jury names people that we could have eligible to serve, Caucasians and African Americans. But we have a hard time capturing jurors that may be Hispanic, legal residents and citizens of this state and this country. They don't register to vote necessarily in the same degree that other constituent groups do. The original law that required forced balancing basically looked at white Georgians and African American Georgians, and if you weren't in those two groups, you didn't get represented in the jury box, and that doesn't really reflect who we are in Georgia anymore. My county has the largest population of Hispanics of any county in the state of Georgia, last I heard. We have a very large population of Asian Americans, but they are not a group that gets included in the forced balancing, and so they arguably may be excluded from being on a jury because they don't get drafted in. So it's not intentional, it's just to comply with the law. And if we go to this system, as I understand it, we're just going to put every name of every person that we can find that can be verified as a United States citizen and a citizen of a county in the jury pool. And we're going to let computers draw those names out randomly. Statistics will tell you that it's going to, on average, you're going to get a jury that reflects your community when you've put all the names in. Now, that doesn't mean that we're not going to still struggle to find additional members of our community to be in the jury pool, because they may be harder to find than others, depending on whether they've registered to vote, they have a driver's license, that type of thing. But we're going to do the best we can, and it's not going to require that our jury commissioners be statisticians and understand calculus to be able to draw this pool together.
good. Thank you so much. I think you have a question.
Yes, sir.
From Mr. Weldon.
I was looking at some other things.
You want to pass or you?
I better withdraw my question.
All right, pass. Well, thank you.
All right.
Thank you, Judge. Glad to have you with us. Next, to have my friend Jack Martin from the Georgia Association of Criminal Defense Lawyers.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, I wanted to address a couple of things. First of all, I wanted to thank Catherine and Jill for incorporating into the sub some of the concerns we had yesterday at the
Yes.
study committee, and those all have been incorporated in here, and those are solving the problems, very technical problems that we had with the bill. And actually, the people who have been writing this bill we've been in touch with them throughout the process, and throughout the process they've included suggestions that we had that I think it helped the bill. I did want to address two things about force balancing and just clarify that. Justice Thompson testified before the Senate committee yesterday that the Supreme Court is increasingly worried about force balancing. I've raised that issue a number of times in cases before the Supreme Court. They have expressed their concern, not enough concern to reverse anything, but
They're concerned.
but they've expressed their concern. I do believe they are rightfully concerned. I think some of these cases, which might get into federal court, and there is a Sixth Circuit case on this issue, on this direct issue, saying that force balancing is unconstitutional. And this may find its way to the United States Supreme Court someday. I did also want to express, as a member of Georgia Association of Criminal Defense Lawyers and as a person who represents people who are charged with crimes, I wouldn't be supporting a bill that I didn't think was not going to increase the representation of minorities on the jury wheel. The problem with force balancing is this. You have these, you start out with the voter registration list, and then since historically minorities do not register to vote in the same rate as the majorities, you get a lower number of African Americans, Hispanics, and others on the jury list, because you start out with a list that doesn't include as many of them as it should. Then, in order to correct that, and it probably was a rough cure at one time in the 70s when we were trying to straighten out a lot of problems we've had over the years, the idea was to force balancing. Now, it never was a law. It was just something that the administrative office came up with, and it was better than doing nothing. But the problem with it is that you get a select type of minority. You get only those minorities who happen to register to vote, which tend to be older, tend to be people who are, you don't get a representative group of that community. Plus, the other problem with it is that you don't, you set yourself up for problems. Clayton County is a classic example. If you're going to force balance based on the 2000 census, Clayton County has changed demographically from 2000 to 2010 tremendously. So you're force balancing it based on 2000 census figures, and therefore what you're really doing is reducing African American representation, because the African American representation has increased greatly from the 2000 census. So it's a flawed, it is a rough method, better than doing nothing, but a flawed method. It has been known for years that the best way to answer this question, the best way to get a jury wheel that includes everybody, is to start out with a list that includes everybody and then randomly pick from it. How do you get the best list? Fortunately, because of computers, we can do something we couldn't do 10 years ago. You take the driver's license list, you take the personal identification card list, you take the voter registration list, and that gives you at least 85%, sometimes much more of the total population. Not only that, you get better addresses, because in voter registration, addresses tend to get old. The driver's license list, the addresses get better, so you get names of people who are more readily contacted through a jury summons. So you can get those people coming in. Now, you might want to even supplement with more lists than that. If you take that 85% and you get younger people, you also get younger people, because a lot of younger people have a driver's license, but they're not voter registered, they're not registered to vote. So you get that list, then you randomly pick from it, and you're going to get a jury that represents the community much better than the force balancing. The problem with force balancing is it is a racial quota, and the Constitution says you can't use a racial quota unless you use it, unless it's for a compelling state circumstance, here, representative jury, but it's got to be the most narrowly tailored means to achieve that. The most narrowly tailored means to achieve this is what we're proposing in this bill, not the quota system that we've been using for so many years. So those, I did want to, there were some concerns yesterday voiced whether this might lower representation minorities. This will help. Not only will we get more representation minorities, we'll also get those portions of the minority community that we're missing in the jury wheel as we stand right now. Just look and see if there's anything. Oh, I've spoken with Senator Cowser, who's the sponsor of the bill in the House, and those, excuse me, in the Senate, and those changes which we've incorporated in this bill, he's willing to incorporate into his bill. So hopefully both bills will be identical as they move forward.
Thank you. That's a good question. Jill, is the same bill, did you work on both bills, or you did?
I did.
And
but of course the changes that you all made today
I
are
understand.
not in the Senate version.
I understand.
As of this moment.
And we'll talk about those as some more tweaking amendments we're coming up with toward the end. Any questions of Mr. Martin? We thank you for coming today and spending your time with us and give us your comments on it. Now we have the other side of the story from President of the Prosecuting Attorneys Council, Mr. Ken Malden. Happy to have you with us, sir.
Thank you. Mr. Chairman, members of the committee, I'm Ken Malden. I'm the DA in Athens, Clark, and Oconee counties, the Western Circuit, and serve as the president of the District Attorneys Association.
I'm sorry.
Joy, that's okay. That's all right. I know there's been a lot of work done on this, and that's to be commended. I commend really Representative Atwood for really dropping this bill and carrying that forward, and all the work that everybody's done on this. I understand it's moving along and trying to move along fairly quickly, but kind of the phrase I've used on occasion is sometimes about, as prosecutors, we have to listen out for that faint voice hollering out from the desert. So if I could just be a moment, just that faint voice to raise some things, I just wanted to bring to your attention that concerns, I think, prosecutors, the DAs across the board. As a general rule, I think this can be done and needs to be done, but we need to be mindful of what happens if there's a challenge to how they did things in Atlanta. And I understood from Judge Studdard yesterday that he'd indicated that the Supreme Court's going to issue specific guidelines about how this will be done. But you understand the council will be doing this for human beings, you know. And if somehow when they come up with the master list across the state and they come up with a master list for each county, if they don't apply things right, somehow somebody makes an error, it could very well affect every jury trial in the state of Georgia and stop that. And I don't mean to be like the person talking about the sky's falling, but just be mindful of that, I think, as we look at this. And how do we make sure that that doesn't happen? People are human. People do make mistakes. And if there's a challenge, and there will be challenges. I mean, I don't believe Mr. Martin and everybody that he represents will basically say there will not be challenge to what the folks are doing in Atlanta. And when that comes down to whatever county and whatever part of Georgia, and that judge there hears that challenge, and if somehow he says that what they did or how they applied what the Supreme Court said they were supposed to do, if they did it incorrectly or if they made a mistake, you understand that could have statewide ramifications. Theoretically, it should only affect that case. But you understand it'll go around to every single jurisdiction as it comes up, and pretty quickly. So I just wanted to bring that up, that understand when you have that centralized like that, I believe there's an issue. Secondly, I think I want to make sure that the bill's real clear about it's not going to affect any cases in the pipeline that where the juries and the grand juries have been okayed by the court on certain motions, and particularly in death penalty cases. Ashley Wright, the DA in Augusta, basically came up here yesterday, and we're talking about she's got 6. She went through the different challenges. The judge upheld basically how those were composed and everything else. And I know these have sunset provisions at whatever time the effective date is. You know, it's 12 months later they're repealed. But I think there ought to be some language here that says we assume everything's going to be good, but there ought to be something this in no way affects any case that's in the pipeline.
Won't that be up to the courts to make if we put something saying you can't use this bill as a basis for bringing a challenge to a prior jury, I don't think that's going to carry much weight with the judge. I've asked Judge Ray back there. Well, I think it goes really more as to what is presented as a factual issue to the court on that type of challenge, would it not?
Well, in death penalty matters, I would expect somebody to raise whatever they can,
Oh, sure.
and I expect them to do that. So if there's
Yeah.
a way this bill can draft it, can add something in there that makes sure that, you know, this in no way, because I thought what was said yesterday, somebody said this is effective, pretty much, Judge Stutter said it would be effective, you know, only affect the cases from the effective date on, and you would assume it's not going to affect the ones prior to that. So I was going to say, if that's the case, there's a way to address it. And third, I wonder about the jury commissioners, what's the purpose of them? And maybe I just need to be educated further, because you have jury commissioners in each county, and they get the list that's been certified as being, this is okay, you know, this is good. Do they have authority to change it or not? And if they do, I think what Judge Stutter said yesterday, and I appreciate this, if they do, then they're going to have to explain why they did it.
That's
Well, somebody may feel that they need to still take that list and try to hopefully not force balance, you know, or hopefully not change it. But if the idea is that we're creating a list that we feel very good about, if it's been done and we're inclusive, and they start removing folks, we're really going to lose kind of the purpose of what we're doing. So my question is it really need to define what they can do, what they can't do, and what are they actually doing? So, but I know, just as a bottom line, the words have been used that this has been scrubbed in Atlanta. The names are, we're going to cleanse a list, I think was used too by Justice Thompson yesterday and before the Senate committee. Is it, which means basically some people are going to be excluded, and there's going to be a challenge about, you know, that process of who did that. And even though they're supposed to have specific guidelines, you want to make sure that they apply those guidelines right, and how they apply them will be challenged. And if somehow they didn't apply them right, it seriously is going to affect, I believe, every jurisdiction and every jury to that extent. So those are some of the concerns I think that I've heard among DAs. So,
All right. Mr. Weldon, you have a question of Mr. Malden?
Thank you, Mr. Chairman. I do. Mr. Malden, is there a specific provision in here that you have concerns about that we can address or try to vet it better that you feel like would make sure that we have due process that's fair to both the state and the
I'd have
defendant?
to. I don't have any specific provision that I can say, yeah, we need to change this or do that at this point. I was kind of bringing up the general concern as to, is there a way to actually, you know, ensure those challenges so you're not having that around the, something happens in whatever county is going to affect everything around the state, you know, and I've got to study it more, particularly the substitute here that we have, and try to do that, and can have our membership kind of look at that further. But I think there's a need. Believe me, we're not opposed to that. I think there's a need, but there are concerns about something happening in Atlanta that's going to affect every corner of the state, you know.
Sure. Okay. And if I could, Mr. Chairman, one other question.
Numbers, yeah. Yes, sir. Go ahead. Excuse me.
I know in the Conestoga Circuit, there's a high, and this is the question I was hoping to ask to Judge Ray, and for some reason my mind failed me. What we have there is we have a high population of Hispanics, and exactly the issue that he addressed is a problem for us. And what we're having is we're having the same Hispanics having to serve over and over each circuit, or not each circuit, but each
term,
jury trial term. And, you know, there are a lot of terms up there.
Sure.
And that's really not fair to them. And, you know, they're going to become jury consultants, you know, by default.
Sure.
So, and I think what he stated was spot on about how this will help not only the system, but this is going to help citizens out there. You feel like that's going to be one of the issues that we're missing here?
No,
Is it not going to have Hispanic representation?
No, I believe where you have an opportunity to basically have everybody involved, I mean, I don't think anybody's opposed to that. The concerns that I raised have to do with making sure that, hey, how we do it here is going to be circumspect, and there's going to be certain ramifications that could very well have some around the state. I'm not certain I can offer you at this time how we could make sure that that may not happen, how we can make sure, is that something that if there's going to be a challenge, it's got to go straight to the Supreme Court? I mean, I don't know. There has to be an evidentiary hearing, but understand, I mean, how people apply the math in Atlanta, you know?
Yes.
People make mistakes. And if that's the case, it could affect everybody because it may affect every single county list that went out to everybody when they cleaned that list, cleansed it or scrubbed it, and how they went about doing that. So you would hope that wouldn't happen. And that's not really trying to be negative about the bill. I'm just raising a concern that I thought ought to at least, you know, like I said, be a faint voice hollering out from the desert. You know.
But you do agree with Mr. Martin and Judge Ray that this is an improvement over what we have now?
I believe very well could be, as long as it's not something that winds up shutting down the system because of whatever reason. It really depends on how it's instituted, really. I mean, and is there some things to make sure that you're not going to have something where everything's shut down? You know, if somebody in Atlanta has to come testify in one county and that same person has to come testify in another county and they have to get a subpoena to testify in another county when you have different challenges going on out of 159 counties at the same time, and who's going to be testifying to those challenges, because there will be challenges. I don't think Mr. Martin, anybody's going to commit at this time there will not be challenges to what's going on there in Atlanta. There will be challenges, you know, and those folks will be testifying at each of those places, and who's that going to be? And that testimony will be passed around, that transcript of where that person testified and what they said about how they did this will go around it. You know, it will be under a microscope times 159.
Thank you. That all, Ms. Weldon?
Yes, sir. Thank you.
Have Ms. Evans?
Thank you, Mr. Chairman. I understand your concern about challenges for what's going on in Atlanta, and I was wondering if you could tell us, are there challenges right now in counties to the way that juries are being picked within the county? That's part one of the question. Then part two is, I understand from some information I got today that a similar program has been enacted in Indiana, and I was wondering if you know if they've had issues like that.
I'm not aware of, to answer your second question, I'm not aware of Indiana and what's happened and what's the challenges there. That'd be, you know, I guess good to try to look to and see what's happened when it was enacted and see what kind of hurdles they'd have to overcome, if there were any, or did it go just real smoothly? I don't know. That would be interesting I think, for everybody. Sure, I mean, in death penalty cases, you're going to get pretty much the same 200 motions and the same challenges, and a lot of times the same testimony. I think Jack Martin's brother testified, I think Ashley Wright's circuit in the 6 different cases that she talked about yesterday, and the judge overruled that. So you're going to have those challenges, sure. You have those challenges, but it affects that particular county at that time. There's not a chance of pretty much that necessarily affecting every single county unless somehow it went up on appeal, went up to the Supreme Court, and the Supreme Court said how they did it was incorrect, and therefore any other county that did it the same way was incorrect as well. But yes, you do have the challenges in death penalty cases, and you're going to still have those challenges. They'll just be a different 200 motions. Well, maybe 150 and then another different 50, I guess. So.
Thank you.
Okay.
Nothing further? Well, Mr. Malden, thank you for coming.
Thank you very much.
Be with us today. I think it might be helpful for the committee to hear from someone representing the clerks, and we have a clerk here. We have also the gentleman who represents the clerks, and if y'all would come up and perhaps be ready to speak to us a little bit more about the mechanics of how this is going to work. From I know the Superior Court Clerks Council is one who will be charged with a lot of the responsibility to compile the list, manage the list, and disseminate by putting the list out to the counties. And why don't you, Mr. Holloman, introduce your clerk. Yes, and tell us a little more about it.
Again, my name is Mike Holloman. I do represent the Superior Court Clerks Association. Just to refer back, I don't speak on behalf of the Clerks Authority. That's a different entity. This is Miss Patty Baker. She is the Superior Court Clerk in Cherokee County, and Miss Baker has been a member of the Supreme Court Jury Commission, or
great,
for the last several years, and has as have several other Superior Court clerks, and of course, defense attorneys, DAs, judges, all constituencies involved in the committee that was led by Justice Hugh Thompson. To, I guess, most recently speak to Mr. Malden's concerns, I can tell you, since I've realized that the Council of Superior Court Clerks is going to be in charge of this,
Yes.
I have woken up in the middle of the night with a slight anxiety, because he's exactly right. This new way of doing thing will be challenged. Clearly, that's the case, and we know that. To somewhat mitigate his concern, though, he referred to Atlanta doing this. In Atlanta, actually, the Council of Superior Court Clerks is comprised of 159 Superior Court clerks from every part of this state, and at least 153 of those clerks have been doing juries and creating jury pools since the beginning of this state.
Yeah, let me ask you this, just to cut through the chase a little bit. This is not something that's not been already, you heard Indiana, and there's other states who have done what we're facing ourselves, which is setting up a central pooling of the information that is then disseminated out to the various users of that information.
In fact, we may be the last.
Well, that's my point. We're not
Exactly.
on the cusp.
We're
are
not
we?
inventing anything new. That's you
So
are correct.
by what we're
We are
doing,
the last state to eliminate forced balancing.
bingo.
Yeah.
So I mean, this has been a constant issue. I know with the courts as to challenges of the makeup of jury pools out of which jurors are selected, and as somebody said, I think Mr. Martin, it's been troubling to the court, although it may not have always faced the need to reverse, but it is a troubling issue that we're trying to clear up.
Yes, sir.
So the fact is, there's already software developed that covers this. There are a number of states using this software, so it's not something like we're trying to prepare our own new road and new software.
The key thoughts are that the system must be totally transparent and auditable.
Right.
And those conditions have to exist.
That's
and
right.
we know that going in. When you anticipate sitting in a appeals court or superior court, and you know you're going to be asked a certain amount of questions, any prudent individual would anticipate that. So transparency and the ability to audit the process from A to Z is critical. That is going to be difficult, but it is certainly well within our abilities.
And what is sent down to the various counties and the clerks who use that information in preparing their own mail-outs to the jurors, potential jurors, you may find, even with that list, there could be, you get back mail saying somebody's moved or whatever, you can pass that information now back up to that central file and have it cleansed of that problem.
Yes, so the bill anticipates a two-way exchange of information.
It doesn't mean you're going to receive a list and say, well, we'll only take certain names off of it to use. We just don't want to deal with all the names. You, as an obligation, oversight by the court, is you use the whole list.
Exactly.
Right. Okay.
Yes, and if I could just illuminate one thing that Mr. Martin alluded to, one of the reasons that this list will be more inclusive, current law says that the jury clerk must use the voter registration list and must use the driver's license list. It doesn't say how much of the driver's license list you have to use. And quite frankly, you could pick one name out of the driver's license list and satisfy the statute. The reason people don't like using the driver's license list is it's a mess. It's got duplicate names all over, old names, and it requires a lot of work, which is well within current technological capabilities, but is expensive and messy process.
Yes.
And that's the reason that you've not had the use of these other lists, specifically the driver's license list, because it is a very messy list.
The problem with the driver's license list is that it's not dated. You might have the same person on there 3 or 4 times. You don't know which is the current address. Someone may move 3 or 4 times within that same county. Their name is there, and there is no way to date the list. And that's part of the problem with the driver's license list. We have to send out surveys. I'll be honest, we'll pick out a random sample of maybe 200 names on the driver's license list. We'll send out a survey. I think I had 35 names that I was actually able to use out of 200 that were on that list that we randomly chose.
Tell me, Ms. Baker, as a clerk of the court, are you supportive of this bill as to the changes being made?
Absolutely, and I can speak if you want me to as far as the cost savings to the county. We waste so much money in postage. I've got the percentages, not just postage, but on sheriff's service. In Cherokee County alone, and I have to say that in Cherokee County we do follow the code section. If it is required for a juror who is a no-show, and that we could not, if we could not perfect service on them, we will send the sheriff's department out to personally serve them. In 2009, we sent the sheriff out to 443 jurors whose summons never came back. So we assumed that they got it. We were able to actually serve 73 of those, and the reasons that the summons came back was either there was no home there, the person no longer lived there, they passed away years ago, and for whatever reason, 16.5% were actually personally able to serve in 2009, 13.8% in 2010. Sheriff's service generally, and the only figure we can go on is sheriff's service costs $50 an average. We all know it costs more than that because they usually generally don't go out just one time. They go out more than that, and it usually will cost more than $50. But based on that alone, it cost Cherokee County over $20,000 just in trying to find these jurors because of bad postage. We summoned for just trial jury, not grand jury, 4,136 jurors in 2009. We're only able actually to serve or who actually ended up serving 2,118.
About 50%.
That's about 50%. 2010, 3,847 jurors we summoned. We ended up with 1,862 jurors actually serving. There's a huge waste out there, and it's not just that. When we try to attempt to use the driver's license list, we have to send out surveys to pre-qualify them. We don't know if they're citizens. We don't know if they're convicted felons. That's not on the driver's list. We have to pre-qualify them, sending out surveys. That's another waste of postage. And when we talk about cleansing the list, we're not talking about removing names. We're talking about improving the list.
Right. It might be pointed out in this new system that we're talking about, there will be obtaining from GCIC the list of felon convictions.
Yes.
In Georgia
and that will be part of the merging.
And whatever can be obtained from other areas also is a possibility. So that's another helpful step for the clerks.
Exactly. And we know we're going to be challenged, but we're challenged now.
Yeah.
So.
Good point. Any questions of Ms. Baker or Mr. Holloman? Well, we're grateful for you taking your time to come be with us today and give us your comments. We have Mr. O'Sullivan, Michael O'Sullivan, representing the Secretary of State's office, who also plays a role in this legislation. Thank you, Mr. O'Sullivan, excuse me.
Sir, I appreciate that. Our office in the Secretary of State's office is more than willing to be a participant in such an endeavor. We have spoken with the Secretary himself, and he has said that even if there was not a legislative requirement to provide such a list, he would be interested in working with the Council of the Superior Courts to provide that voter registration list on his own. That being said, in looking at the bill itself, there are 3 sections that affect the Secretary of State's office, Section 65, 66, and 67, which all are in Title 21. And I was just hoping to point out that I believe that there's a bit of duplication in that some of the areas that are being included in the code do not necessarily, in our opinion, need to be in there. If all that you are looking to do is to have the Secretary of State provide to the Council of the Superior Courts such a voter registration list, the end of Section 67 in my bill, it's 1179 to line 1186. That section right there should provide all of the information that that is needed. The previous sections are, in our opinion, unnecessary and get into some other areas that are somewhat problematic, and I can explain that if you'd like, the reasons why they're problematic, but nonetheless, I just wanted to point out that I think that that just that Part G, in our opinion, is all that is necessary should you go forward with including this. And again, if you do not include us, we will still be willful participants in such an endeavor.
While we're at it, go ahead and tell us what are the other portions of it that you see as being problematic.
Sure. In Section 65, this is the is the authorization to procure and provide the equipment for the Board of Registrars to be able to utilize the official list. This is the system that we use to add individuals to the list, to mark them as felons, to mark them as deceased, whatnot. If all that the council is looking to do is have that list, they are not necessarily needing to be able to make changes, which Section 21.211 would. That's the system that is being discussed. Is the system to be able to have the Board of Registrars. It's a two-way system where we would send them lists, they would make some changes and send it back so that we have an updated list.
Okay.
In Section 66, it's actually a little bit even more problematic. The first strike, it strikes the month and day of birth and replaces it with date of birth. This is the information that is kept confidential. So the voter registration list is confidential currently. Any individual that's registered, their month and day of birth are confidential, not their year of birth.
All right, the confidentiality is by statutory direction. So what we're saying here is, again, by statute, as a means of knowing we've got the same Mary Jones,
yes, sir,
we want to have a date of birth as a way of potentially making that comparison by computer.
Yep, yes, sir. The very first part, and I'm working off the original bill. I don't have a substitute, but I think they marry pretty closely. Got right to it. Line 1100. What this essentially means is that, and this was, it had originally said date of birth was confidential. The legislature changed it to the month and day of birth because year is an important part of a voter registration list. A person would like to know their makeup of their community. Professors of universities would like to know statistics as to which areas, the ages of the population. And then when you move down, then it gets into the provided that all the information related to the dates of birth, social security numbers, driver's license numbers may be made available to other agencies of the state. So even though the month and day of birth are confidential currently for everybody except for another agency of the state, which the council would obviously fall under. So they already are being taken care of. However, I don't know the reason for it, but in lines 1105 through 1106, they strike agencies of other states, territories of the United States, and agencies to the federal government. That limits our ability to share our data, for example, with the state of Florida. If we were to work with them to identify any potential areas where people are registered twice, which we have recently done, this limits our ability to do so, and I don't necessarily know the reason for making such a strike.
Let me inquire of Ms. Travis, do you know the basis behind that being struck through? I don't either. I don't think anybody has a clear reason why that was taken out.
Okay. And then when you move on to lines 1110 through 1115, again, all that this portion says is that all the information relating to the dates of birth shall be made available to the superior courts.
Right.
All that is already covered under line 1104 and 1105 as another state agency. So it's a duplication of what is currently out there. For example, our office does provide the voter registration list to the administrative office of the courts. This falls under them. They get a voter registration list, the same list that we would provide to the Superior Courts Clerks Council. And so I don't necessarily know that this additional paragraph.
It does address also driver's license numbers, which would be, I think, something separate from what you have in your database.
Line 1104 addresses drivers. At the end of 1104, addresses driver's license numbers. And then line 1121 and
as I said one time in a committee, we do a lot of duplication in bill drafting, so it's not.
Yes, sir.
Not always.
And then line 1121 and then 1124 and 25 say the more or less the same thing, that the information should be provided and then free and then in electronic format, which then in line 1184 and 85 it says such data shall be provided in an electronic format. So in essence, what I'm essentially saying is I believe that we can provide everything that the council is asking for if you were to simply just leave it at Section G in Code Section 21.2.231.
All right.
Thank you, sir.
Thank you, Mr. O'Sullivan. Ms. Travis?
I understand what Michael was saying about G, but it seems to me that 225 relates to the confidentiality, and don't you have to somehow get it out from under the confidentiality?
What now? You're talking about 20? What?
In Section 66 of the bill deals
Yeah.
with the confidentiality information.
Yes.
And Section 67 of the bill deals with the monthly transmitter information.
Right.
And I think that the part of the reason why there's some duplication is that you not only wanted the information to go there, but you also wanted it to not be confidential in terms of the Secretary of State's release of the information.
We're being able to do it.
But as another agency of this state, that information, the confidentiality, is removed with lines 1104 and 1105. Any and all information related to the date of birth, social security number, driver's license number of the elector may be available to any other agency of this state. So the confidentiality issue should be resolved with that line.
Okay.
Thank you.
I say it's duplicative, I guess is the word, but maybe that's what we'll have to live with. But no question then about it.
Yes, sir.
Thank you, Mr. O'Sullivan. Any questions of Mr. O'Sullivan? Further comment? Yeah.
I would just like to say that at the very least, the beginning of Section 66, those couple changes, and then 65,
Yes,
that is problematic, sir.
I think putting back in agents of the states so we don't have that problem. You're having to go outside the state of Georgia if you're dealing with another jurisdiction and wanting to share information. You can't say, well, we've been denied, and they say, well, you don't get ours either.
Yes, sir. Thank you.
All right, thank you. We have anyone else who would like to address the committee on House Bill 415? If not, then we will. Yes, ma'am. Please come forward. Oh, that's right. Come forward. Come forward, please do. We've got some amendments that I think may cover what you and I addressed earlier today, but be helpful for you to address it before the committee. Then we can talk more intelligently about it.
Thank you, Mr. Chairman, members of the committee. My name's Sherry Lang. I'm with the Georgia Bureau of Investigation, and today I have with me Neil Gerstenberger, who is with the Georgia Crime Information Center. And there are just a couple of things that we need to point out to you that are in the bill regarding the GCIC.
We're looking at Section 67, I believe, isn't it?
Yes, sir.
Yes, sir. Thank you, Mr. Chairman. A couple of things to point out, if I may. And one is that the criminal history database, we do not collect address information.
Right.
So that is not something that would be available.
Yeah. I've got an amendment I think will take care of those things that you and I talked about earlier.
Yes, and age versus date of birth.
Right.
I mean, those kinds of things. And then other information that's prescribed by the Secretary of State. I mean, there are only certain data elements that we collect, and I think that would be.
Mr. Travis, hand me those amendments, if you would, please, just as I can have it.
They don't include everything that needs to be done, I don't think.
Do not?
I don't know.
All right, well,
Mine.
did you didn't draft one out, though?
Did I draft one?
I thought you were going to get something drafted out as a.
Yeah, I thought you just wanted me to bring that with you.
Okay. I think we.
But the one thing I wasn't clear about was the as prescribed by the Secretary of State's in there a couple times.
I understand. I'm dealing with the GCIC, and what we're looking at is from the lines are identified on this bill starting at 11:30. I'm going to read what we're proposing here, and that is, unless otherwise notified by the Secretary of State, the Georgia Crime Information Center shall, on or before the 10th day of each month, prepare and transmit to the Secretary of State a complete list, and I've struck out in a format as prescribed by the Secretary of State. That's something y'all just work out how it has to be done. Prepare and transmit to the Secretary of State a complete list of all persons, including date of birth, Social Security number, and other available information, as prescribed by the Secretary of State. Would that do it?
Yes, sir.
On that part?
Yes, sir.
Then going over to the next page, our next area, who were convicted of a felony, and striking out involving moral turpitude, as that's a term that you shouldn't have to try to determine what is a crime of moral turpitude, during the preceding calendar month in this state. Then you had another one down further there on line 1140 that we took out again. Crimes, Georgia electors convicted of felonies outside of Georgia involving moral turpitude, and I said when available from other states, as opposed to if possible. That covers it.
Did you take out involving moral turpitude?
Yes,
in
ma'am,
that?
I did.
Okay.
Took that out. So it just leaves it as felonies when in other states when available, from other states when available. Leave out if possible.
Well, currently there's no, I guess the question is how on that, because there's really not currently an avenue to do that.
Not available.
Right, yes, sir. Right, yes, sir.
If ever you to perfect something like that, then that could be perhaps more data that could be available.
But I would also like to mention that there are some budget considerations involved here. There are going to be some programming costs with our vendor. This is currently not available, so there are some other things.
True, and I think I hope I addressed that in the beginning.
Okay.
It'd be helpful to get some figures from your agency. This whole thing is contingent upon there being funding available to meet the cost needs, and that is, we think, somewhere in the range, as small as it may sound, $100,000, but there's still a work in progress. So if you can provide to us your expected budget constraints, we can look at that.
Yes, sir. We'll be happy to do that. And just one other issue, which we deal with quite often, is again that this is a name-based list that we will be being provided versus fingerprint-based. So you have your false positives, false negatives, and some of those issues to deal with.
That's going to be, and I think that goes to the mechanics of what you'll be working out with the clerk's council and other information compiled through the Secretary of State for that. Correct?
Well, if we're providing a list of those people convicted, it may not necessarily be the same as the person on the list because someone has used a false name or this or that.
Right.
You know, we have all those issues that could just bring
Can't-
in.
Yeah, can't correct
ancillary-
that. What we're saying is
Right.
you're going to have a name of John Jones,
Yes, sir.
and that John Jones has a Social Security number in your database. It also has a date of birth, and that is what comes over to the list as a master list that will then be compared through the software available to see if there's a John Jones, that same date of birth and Social Security number. Then we probably have a positive. If it comes out different, then somebody's got to look at it and make a correction on it.
I'm sorry. Oh, well, yeah, that could be, again, because it's not fingerprint-based, but also, as we were talking earlier, most counties do report their dispositions electronically, so we would probably receive those fairly quickly. But in other cases, it really should be the date the record was last updated, because if there's a term of court that's quarterly or something, you know, it's what's going to be on the database at the time the record is run.
Well, we talk about a monthly basis.
Right. But a person may have been convicted at the end of the month and the clerk didn't transmit it, you know, so I'm just some little.
Can't be to the minute, but we're trying to give at least a reasonable time frame.
Yes, sir.
Pull that information in. Okay. Great.
Thank you,
those,
Mr. Chairman.
Those suggested changes clear up the concerns you all have?
Yes, sir.
Does it? Good. Thank you for coming and being with us today and testifying. Do we have anyone else who would wish to address the committee? If not, we will close all further comments from the public. The bill is now in the breast of the committee. Do we have a discussion among the committee members? Do I see Ms. Stevenson?
Yes, Mr. Chair.
Yes,
I have
ma'am.
comment to make.
Sure.
And to the author, I thank you for carrying the bill. For Attorney Martin, thank you for some of the changes as the people are working together. I just want to make sure we all realize that this concept or the attempt to eliminate the forced balancing is not a new concept. We've been talking about it from several years. We start off with, notwithstanding the fact that the courts don't see it the way a lot of us attorneys see it, to start off with a flawed denominator called a voter's registration list and the driver's license, and then to top it with the numerator has not really been the same purpose as we would like to have it. So I see this bill, knowing it's going to be some amendments, with at least an attempt to eliminate some of what forced balancing was, to eliminate discrimination, but in fact it helped set us up for the challenges. Now, are we still going to challenge? Probably so. But the idea that we're starting with a better state of statistics with reconciliation, some people call it cleansing, I call it reliability and credibility. At least this bill is taking into account where we should go rather than where we are now.
Good
so I
comment.
support the bill.
Thank you very much, Ms. Stevenson. Mr. Weldon, did you?
Yes, sir. Thank you, Mr. Chairman. One of the things that I wanted to ask that I didn't ask earlier, how the payment be enforced with the counties, and maybe the clerks can answer that.
We've talked about a subscription in here, and that's based upon the section toward the end, which is saying up to 3 cents per name per year. And what section was that again, Mr. Carroll?
Section 16 at the end.
16.
Subsection D.
What section number again?
16 or 67? Which one is it?
13. Okay. I've been through this. Yeah. And so what you'll have is what we call a subscription amount that is really up to that 3 cents, not to exceed, and the council will have to make a determination each year what may be the general cost for allocating to each name that it has in its database, and that would then be billed to the counties for the access to this service, and they're required to use this service. So I say by access, they're going to be a participant, and that's how the fee would be established. And we, as was testified by Ms. Baker, we expect there would be a substantial cost savings. It won't eliminate every problem as far as mailing, but it should help clear up a lot of the duplications or problems they have with mail coming back. Mr. Carl, you want to say something? Come up here to the witness place, if you would, so everybody can hear you.
Sorry. I wanted to particularly address Representative Weldon's question on enforcing the subscription fee. Part of what is anticipated is implementation rules to be promulgated by the Supreme Court, which would set forth what the business processes are to create the list. What is anticipated is what is being talked about with Justice Thompson, Judge Ben Studdard, and others, is that the vendor would provide the county master jury list, much like a product, that you would provide someone, and then that's at the point at which you know what the subscription cost would be, because you say, okay, there's 12,000 names on this list, and that is, somebody can do the math, at $300, maybe for a county. Here's your invoice, and at that time, the county would be asked to pay that invoice, say within 30 days, what have you. At which time, what the Supreme Court, there's another step that the Supreme Court wants to see, and that is a certification that the business rules have been followed and that the standards for the list have been set, and those are inclusiveness thresholds. So it has to be this good of a list to be certified. After payment, and again, this is what is anticipated, the vendor would then provide the certification that it meets, that the list meets those business rules, and that indeed meets the threshold standards set forth by the Supreme Court.
Good. And how are you going to enforce that they pay it within 30 days?
I've never had to enforce anything with the counties in my life, so I'm not quite sure. But again, the carrot.
Get rid of mandamus or something like that. All right,
the carrot.
You
get in the weeds, I think, a little bit.
No,
but they'll come through. They gotta have the list. The law compels them to use the list, so they've got to be able to get their access. Access depends upon payment.
And I truly believe that there will be a cost savings to the county. It would be per record that the county did receive. The small counties will be paying a very small amount. The larger counties will pay more because they obviously have more names on the list.
All right. Thank you. Further discussion among the committee members? If there's none, Chair will entertain a motion. How many we got now? 1, 2, 3, 4, 5. I'm barely holding a quorum. That's why people say, "Oh, y'all increase the numbers." Thank you. Where's everybody gone? Ms. Stevenson was here. She left.
Her phone's here, but she's not far away.
Okay. See if she's able to. She may have stepped out for personal reasons. Do we have anyone else? All right. Let's wait till we get some heads in here. Appreciate it. Just hold me a minute. Everybody's got so many meetings right now because we're getting close to the day 30. Really?
Jill never would have done this, though. She could just keep me out of her office. Probably get a lot more work done.
We have another Superior Court judge with us, Judge Catherine Gosling. Good to see you from Gainesville. Always a pleasure to have you here with us. And didn't mean to bring you back, but we're so short of people.
Oh, I didn't know you
Sent the bailiff for you. That's all right. We're still kind of a slim number, but we do have enough for at least motions and debate be made. Chair will entertain a motion.
Move to pass.
Have a move and second do pass. And we do have, I think, proposed amendments. I'm going to recognize Ms. Travis because she's been working on some things for us. Ms. Travis, would you deal with what you may have as amendments, and we'll take them one at a time?
Okay. I'm gonna work on page 34.
All right.
And I'm in the lines 1130 to 1141.
Yes, ma'am.
And what I'd like to do, if I could, rather than say what goes away and what stays, if I could just read to you what it's going to say.
All right, so what we'll say, we're going to remove the current paragraph A, and you have.
Well, I'm going to use a lot of the language that's.
I understand, but you're going to read the whole thing as a proposed amendment.
Okay. Unless otherwise notified by the Secretary of State, the Georgia Crime Information Center shall, on or before the 10th day of each month, prepare and transmit to the Secretary of State a complete list of all persons, including such persons' date of birth, social security number, and other available information as prescribed by the Secretary of State, who were convicted of a felony in this state since the preceding reporting period. Secretary of State may, by agreement with the Commissioner of Corrections, obtain criminal information relating to the conviction, sentencing, and completion of sentencing requirements of felonies.
Period. Okay.
Additionally, the Secretary of State shall be authorized to obtain such criminal information relating to Georgia electors convicted of a felony in another state if such information is available.
And that's pretty much what we talked about earlier. So that is, I will propose that as an amendment as a new paragraph A. Do we have a second to that proposal? Second. Been made and seconded. In discussion on Amendment 1, Willard Amendment 1, all in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments, Ms. Travis?
Well, I don't know what y'all want to do with respect to Mr. O'Sullivan's comments regarding Section 65 and 66.
I am of the mind that I agree it may be maybe duplicative, but I think we're going to leave it as it is for a reason that it came as a proposal within, and I say if it's repeating something, at least there's clarity that you got to have it done. Okay. Let's see. Do we have other amendments? Ms. Stevenson?
Clarification, Mr. Chair, does that also include lines 1105 and 1106 under Section 66?
I thought there was something else, yeah.
I believe,
you're right.
yeah.
That's where I was. Thank you for bringing it to my attention.
You're welcome.
I think what we're going to do, if I might suggest, based upon Mr. O'Sullivan's requesting, and that is at lines 1105 and 1106, where we have the following deleted. It says agencies or others. I'm sorry, agencies of others. Have dinner. Thank you. I know. We were waiting for you long enough.